appeal in the matter of Providence Building Services Ltd and Hexagon Housing Association Ltd.
Yes, Mr. Channels, Mr. Lewis, before we start, we've read the papers. We have a good grasp of the issue. We think the issue is A, interesting, B, short. So obviously you'll take your own course, but we'd be reasonably confident you could do this in half a day. That's our view. Over to you.
My Lord, I'm grateful. My Lords, I appear on behalf of the appellant in this appeal, claimant in the proceedings, Providence Building Services Ltd. My learned friends, Mr Lewis, King's Counsel, and Mr Kaplan for the respondent, defendant, Hexagon Housing Association Ltd. My Lord should have, I hope, 3 bundles, a core bundle, supplemental bundle, and the authorities bundle in hard copy and electronically. I think that the supplemental bundle is the only bundle where the electronic PDF pagination diverges, I'm afraid, from the hard copy after some inserts were made. That's limited. My Lords, this is an appeal from the order of Mr Adrian Williamson, King's Counsel, sitting as a Deputy High Court Judge in the Technology and Construction Court, and concerns the proper construction of Clause 8.9 of the parties' contract, which incorporates the JCT 2016 Design and Build standard form. My Lords, if you would be good enough to go, please, to the core bundle. Behind tab 6 at page 65, you'll find a copy of the order appealed, which His Lordship made 2 declarations, paragraphs 1 and 2. The first as to the construction of the contract, and the second as to the status of the appellant's termination notice of May 2023 in the light of the court's finding on that point of construction. We respectfully ask the court to substitute that with an order to the opposite effect, as set out in the core bundle behind tab 1 at page 7. The clauses relied upon by the parties, my Lords, have been transcribed at tab 11 of the core bundle. And if my Lords would be good enough to go, please, to page 89, you will find the clause central to the appeal, clause 8.9, termination for default by the employer. For my Lord's notes, you can find as parts of the original contract that provision within the supplemental bundle at tab 5, clause 8.9 appearing at tab 5, pages 84 to 85, it's the standard form, and pages 164 to 165 are the amendments.
Thank you.
Clause 891, as my Lords can see, identifies certain breaches of contract which can be the subject of a notice, and if so, those become specified defaults. Clause 8.9.2, which is not here transcribed, concerns specified suspension events. Clause 8.9.3 provides that if the default continues for 28 days from the notice of specified default under 891, then the contractor can, on or within 21 days of expiry of the 28-day cure period, terminate. And I'll refer to that, my Lords, as termination for continued specified default. Key provision is, of course, 894, which provides that if the contractor for any reason does not give the further notice referred to in clause 893, but whether previously repeated or not, 1, the employer repeats a specified default, then upon or within 28 days after such repetition, the contractor may, by notice to the employer, terminate the contractor's employment under this contract. The question for the court is as to whether the right to terminate under clause 8.9.3 must have first accrued but not been exercised before Providence, the appellant, could have a right to terminate under 894. I propose to address the court in the following sequence, if I may. First of all, the background, introducing the court very briefly to the facts, delineating the scope of the proceedings, introducing the court to the judgment below and the grounds of appeal and respondent's notice. I'll take that quickly, if I may. Then the approach to the question of construction, picking up some of the authorities. And in that regards, my Lord, again, I'll be quite brief because much is common ground. I'll then move to the wording of the contract. Third, fourth, the iterative process of checking the rival meanings and their consequences. And then finally, quite shortly, fifth, what might be taken from certain other materials to which regard might be had in approaching the question of construction. So, my Lords, the background and the facts. You have the chronology at tab 5 to the core bundle, which is short. Contract was entered into, as my Lords will have seen, on the 27th of February 2019, incorporating the JCT standard form. The original contract sum in the region of £7.2 million. The next few entries on the short chronology concern the first late payment relevant to the present appeal, certified on the 25th of November.
Well, this is all agreed, isn't it?
This is all agreed,
Background,
my Lord, that's absolutely right.
So, I mean, there was a late payment, but paid, as I understand it, before the 28-day period had expired.
That's right.
And that's the point.
That's the point. And the second late payment was then the late payment that led to the termination notice. Our Lords have the notice of specified default that was served in respect of the first late payment in the supplemental bundle at tab 1, page 2. You don't need to turn that up now. The termination notice can be found in the supplemental bundle behind tab 2, and I would like to show the court that document quickly, if I may. So that's at page 3 of the supplemental bundle. It's 2 pages long, my Lords.
Yeah.
The first page sets out the termination on the clause 894 basis, relying upon the notice of specified default that we've identified, and the repeated default by failure to pay, that payment notice 32 in May 2023. The second page sets out that without prejudice to the contractual termination, in the alternative, the contractor terminated at common law. Can I draw, please, the court's attention to the second paragraph? In this regard, you've consistently failed to comply with one of the most important obligations under the contract, i.e. obligation to pay Providence interim payments certified by the employer's agent, as being due to Providence by the final date. Indeed, of the 32 interim payments certified by Bailey Garner as being due to Providence to date, you failed to pay 19 of them to Providence on time, and the payment delays reached as long as 35 days. This was despite repeated complaints about lateness, despite the notice of specified default. And so it goes on and refers to the accumulating cash flow consequences towards the end of the paragraph. I draw that paragraph to the court's attention simply because I would not want the court or any interested observers to take away a false impression of the case, to the effect that this is a case in which my client sought to terminate the contract in the context of 2 late payments, albeit that the first was not insignificantly late, and both were for very substantial sums, even if my client was entitled under the terms of the contract to do so. Rather, it's the appellant's case in the action that a very substantial number of payments were late to varying degrees and with real and important consequences. Indeed, that a very substantial number of the payments are late has to date been common ground.
But just to go back a little bit, it's common ground, isn't it, that the second late payment, as outlined in the chronology, was for the purposes of 8.9.4.1 repeating a specified default?
Yes, my lord.
And the specified default is not failure to pay number 27, but failure to pay in accordance with 4.9.
My lord, that's correct.
Good. Thank you.
When it says the payment delay is reached as long as 35 days, does that mean all added up, or does that mean there was one which had taken 35 days?
My lord, I understand that to mean there was one which reached 35 days.
But that wasn't relied on invoke 8.9.4, which on either side's case would be sufficient.
Well, my lord, that's right. It may be that the 35 days, and I can't give you a precise answer to this, but it may be that the 35 days in delay was from the final date for payment rather than a notice of specified default, or it may be that the 35 days is calculated in some other way.
I follow.
Certainly, there was no, it is common ground, there was at no stage a right to terminate under 893 for continued specified default.
I follow. Thank you.
So, forgive me, I'm afraid I have the point, but I can't give you a precise answer. My lords, just to bottom off this point, I've shown you this for the reasons I've given. The precise dates, precise delays, and the circumstances and consequences of those late payments are, to a greater or lesser extent, controversial. No findings were sought on those matters below, and so obviously none are sought on this appeal. The focus has, so far as these proceedings are concerned, been restricted to the two late payments relevant to the notices upon which the contractual termination is founded, that being all that is necessary for the purposes of the present action. For its part, the respondent contends that Providence had no right to terminate under 894. That was initially put on the basis there had been no notice of specified default under 891, but subsequently it was accepted that that was wrong, and the respondent put its case on the current ground, viz. No right under 894, if there had not previously been a right under 893. The respondent has also indicated that it will say that notice of termination was given unreasonably or vexatiously, so fell foul of the 821 proviso, and in the circumstances the respondent's case is that the appellant was in repudiatory breach of contract.
When we don't have to decide any of that.
You don't have to decide any of that.
You just want us to decide, can you give an 8.9.4 notice if you haven't got an accrued, have never had an accrued right under 8.9.
My lord, that's exactly right. It's exactly right, and that's the scope of the proceedings point. My lords will be familiar with the judgment below. You'll find it behind tab 7 of the core bundle. Paragraphs 1 to 8 on page 68 of the bundle summarise the facts that are reflected in the court's chronology document. Paragraph 9 refers to an adjudication that took place on the issues. Paragraphs 10 to 12 identify the contract and the relevant provisions of the contract. Then over at page 69, paragraphs 13 and 14 identify the legal principles, to which I'll return separately in a moment. Paragraph 15, the issue before the judge, to be resolved primarily by reference, the judge said, to the wording. Paragraph 16 introduces clause 893. And then paragraph 17 introduces the point about an active step serving a notice or not being anticipated by 894. And then paragraphs 18 and 19 contain really the kernel of the judgment below, concluding that the clause means, this is 894, requires that a clause 893 notice could have been given, but the contractor decided not to do so for whatever reason. Over the page at 70, paragraphs 21 and 22 consider clause 843, that we'll come on to in due course, the employer's corresponding right to terminate, concluding that it's to be interpreted in the same way as 894, in reliance upon his lordship's emphasis on the does not give wording. It's at 22. At 23, the iterative process starts, and the consequences of the respondent's construction reliance upon alternative remedies, providing to the learned judge's mind, the answer to that part of the case. And then at 24 to 26, the judgment addresses the consequences of the appellant's construction of the contract and makes essentially 2 points. First of all, that there's an entitlement to terminate where very small underpayments have been made or a very small delay in payment, and that is not adequately answered by reference to clause 8.2.1 and the proviso in terms of unreasonable or vexatious, describing that as tricky and nebulous. There is at paragraph 27 a point about asymmetry that only arises here insofar as Hexagon contends that 8.4.3 and 8.9.4 are to be construed differently. I'll come to that in due course, my lords. And then over the page at 71, paragraph 28, the judge's conclusion that business common sense arguments don't really advance matters, paraphrase, and at 29, his lordship didn't gain any real assistance from the Rainwood case or the guidance notes to this 2016 edition of the JCT4. My lords will have seen the grounds of appeal behind tab 1 of the bundle. That's at page 14. Ground 2 has essentially fallen away as being to do with the additional grounds or additional reasons as to why permission to appeal ought to be given. So we are concerned with ground 1, which comprises 5 sub-grounds, the first 4 of which concern the wording of the provisions at hand, and the 5th concerns the implications of the parties' rival interpretations. For its part, my lords, the respondent behind tab 2 at page 18 contends that the judgment ought to be upheld for additional grounds. 2 of them. First of all, that the respondent's construction is more consistent with business common sense, and indeed the appellant's construction defies commercial common sense. And then second, that the respondent's construction is supported by the wider commercial and contractual context, including e.g. the guidance notes. I hope I haven't trespassed on the court's patience too far in that short introduction.
No, thank you.
I'll turn now, if I may, to the approach to the issue of construction. And as I said at the outset, to a significant degree, my lords, the principles to be applied are, as one might hope and expect them to be, agreed between the parties. The differences very largely concern the application of those principles. What I'll do is I'll start off by identifying, if I may, the agreed principles before moving to those that might be slightly more controversial, of which there are, I think, 3. Amongst the core principles, first of all, the parties rely upon the judgment of the Chancellor, as he then was in the Lamisa case, which you have behind tab 1 of the authorities bundle. And the court's attention will be invited to, in particular, page 8 of this bundle, paragraph 18, where his lordship helpfully summarised the effect of the triumvirate of Supreme Court cases.
Actually, I think these are Judge Pelling's summary.
My lord, that's right.
No worse for that. I'm just saying that this is the MR setting out Judge Pelling's summary of all the guidance recently received from the Supreme Court as to contractual construction.
My lord, indeed, I didn't extend the credit as far as I should have done. At all events, paragraph 18 is, so far as that court and these parties are concerned, an accurate and helpful summary of the relevant principles.
Oh.
See also paragraph 23 as regards, and that's on page 12, the iterative process of construction. I won't read that out. Those are very well-known principles. If I could invite the court's attention, please, to paragraph 21 on page 11,
Point about standard forms.
The point about standard forms, precisely. Focus being on the wording used, wording which should be taken to have been selected after considerable thought and with the benefit of the input and continuing review of users of the standard forms and knowledge of the market. Obviously, we place emphasis on that, given that the court's concerned here with the standard form in wide use, and that's understood to be common ground as an appropriate approach on this appeal. The reference to that is the Respondent skeleton at 3.4.
But this isn't one of those cases anyway, is it, where the parties are at odds as to the factual background or context?
Not so far as it's
This
relevant.
is a contractor and a housing association.
The only, I suppose, the only point that is not, or that could be described as bespoke, is under 8.9.3, the increase in the period from 14 days to 28 days,
Yes.
which might be said tangentially to go towards the idea that an employer might, by mistake or inadvertently or whatever, not pay. The longer the period, A, the less relevant it becomes an inadvertence argument, and B, the more serious the delay or the ultimate period. Is there any other relevance to the in the amendments?
Not in my submission. No.
And there's the change from reasonable time to 28 days in 8.9.4.
Yes, indeed.
That's about it.
That's about it. My Lord, you have the amendments, as you say, in red text, and I place limited or no reliance upon the amendments. Before, my Lords, I leave the Lemisa case, may I make one point about commerciality in the iterative process? At various points, the respondent characterises my cases involving a submission that its construction is uncommercial or wholly uncommercial. See, I'll just give the references if I may, 513.1, 518, 519, and the respondent's notice.
Sorry, what's this tab?
So
Tab 5?
This is the respondent skeleton, so it's core bundle tab 4, pages 56 and 57. And the paragraph references are 5.13.1, 5.18 and 5.19. And there is also the respondent's notice that makes the same point. In other words, characterising my case as being one that the respondent's interpretation is uncommercial or wholly uncommercial. I wish to make clear I don't go that far, and I don't need to go that far in presenting my appeal. Rather, I do make the submission that the respondent's interpretation is less commercial, so that when the court weighs the competing consequences of each party's case in the balance, it speaks in favour of the appellant's construction. And that is consistent with the approach elaborated in the authorities, which one can see at page 10 of the authorities bundle, with a citation from Lord Hodge's judgment in Wood and Capita towards the bottom at paragraph 11. So his lordship refers to the unitary exercise, whether a rival meanings the court can give weight to the implications of rival construction.
I'm very sorry, I missed, where are you now?
I'm on page 10 of the authorities bundle, my lords, so we're in Lemisa. This is the one point I wish to draw the court's attention to.
And you're in paragraph what?
And at the very bottom of the page, in paragraph 50 of the judgment, his lordship is citing what Lord Hodge said in Wood and Capita. He sets out paragraphs 10 and 11 of that judgment, and the extract from paragraph 11 is the one to which I draw attention. Interpretation is, as Lord Clark noted in Rainy Sky, a unitary exercise. Whether a rival meanings, the court can give weight to the implications of rival constructions by reaching a view as to which construction is more consistent with business common sense. So it's a question of weighing in the balance, rather than having to conclude or driven to submit.
What do you do if you can see a commercial logic for either?
Well, this is in a sense my point, my lord. There are two possibilities broadly. one's a gateway to the other. Proper approach, in my submission, is to weigh the competing considerations in the balance, and the court may conclude that although there is commerciality about both, on one side it's weightier than the other, and that points in favour of that party's interpretation. That's what I say is the position here in my favour. The court could conclude that it's an equal balance, in which case questions of commerciality don't take the court further as one of the tools that it has at its disposal. Which is, I think, where the learned judge below arrived. May I pick up some further points by reference to the respondent's skeleton, which you'll find in the core bundle at tab 4. Can I pick it up, please, at page 46 of the bundle? Briefly, I hope, just wish to identify for the court what's common ground and what isn't, and where it isn't. Tell my lords what I say about it. So paragraph 3.3 puts forward the proposition that the more uncommercial or unreasonable the consequences of a particular construction, the greater is the need for clear wording. And Whitman and Schuler is cited, and that's common ground. We say it's of no application here. Paragraph 3.4 essentially agrees with the point about standard forms we touched on earlier. And then at the bottom of page 46, over to 47, however, the relevant factual matrix can include the general commercial background to the terms in the standard form. The regard can still be had to the commercial consequences. That is common ground. 351 is not agreed. And I'll come back to that paragraph in a moment. It's one of the 3 areas of apparent disagreement. I'll refer to that as the repudiation point.
Excuse me.
352, contractual termination clauses is to be strictly construed. And 353, contractual termination clauses must be strictly and exactly complied with. That is agreed, those propositions.
But it doesn't really matter, does it? Because once we decide what the clause means, there's no doubt about what the end result will be, one way or the other.
Well, that's
so there's no separate argument. If we find in your favour, there's no separate argument based on strict performance.
My lord, that's right. There is no separate argument based on strict performance. In this case, we're concerned with the interpretation of the clause itself rather than compliance with it. There may be something in the point that contractual termination clauses are to be strictly construed, given the emphasis I place upon the words that the parties selected.
What does that mean, strictly construed?
Well, in my submission, the appropriate approach to termination provision is to fix first and foremost on the wording and the ordinary plain meaning of the words that the parties chose, rather than stray too far beyond that, because in the context of a termination clause, it's of particular importance that the parties can rely upon the words that were selected.
But I still don't understand what's meant by strictly construed. I quite understand that the fact that the consequences are that if the clause is triggered, it results in termination. That's part of the iterative process, and that may cut both ways. But I don't really understand what's meant by the word strictly construed as a matter of an approach to the language.
The way in which I'd understood the proposition was that one would have potentially less regard to questions of context or commercial background or consequence the other tools that one has at one's disposal, and would place a greater emphasis upon the words that the parties had actually selected.
It's not the greatest of authorities, is it? Because Struthers refers back to Robin Ellis, which itself cites a passage from Keating and a passage from one other book, and that's it, isn't it? And they're both first instance decisions.
I think that's right. I think
I mean, there's no real basis for departing from the principles of construction that the Supreme Court have given us in about 5 different iterations.
no, I think that's probably right. But as I say, I do make my submission that in a case such as this, A, because it's a standard form, B, because one is concerned here with a termination provision, additional emphasis ought to be placed upon the
But I
word.
still don't understand, forgive me for pressing on this, I still don't quite understand what is meant by strictly construed. Does that mean if you're left in any doubt as to whether a termination clause means something, you should back off or give a less draconian, because here we've got 2 possible interpretations, each of which has significant commercial consequences, whether you can justify them or not. And you've got the provisions of 8.12 or whatever it is about what happens if you terminate under 8.9. Like my Lord, or certainly like my Lord about 2 minutes ago, I don't understand what is meant by strictly construed when you're trying to interpret what a clause means.
Well, my Lord, I hope I'm not repeating myself or failing to help. But in certain cases, one might say, well, the natural, the ordinary meaning of the words that the parties have selected might be A. But here in this context, we get indications from perhaps, as my learned friend might say, the flow of the clause or the structure of the clause, that actually those words don't have the literal meaning that one might think they do. I would encourage the court not to go down that route, but to consider that in the context of a termination provision, the literal meaning of the words that the parties have selected is to be given primacy. It ultimately may.
I mean, maybe we don't need to spend a lot of time on it, but the language is rather redolent of the old exemption clauses being strictly construed, which meant construed against the party seeking to say they amounted to an exemption. In that sense, that this would be rather unhelpful to you.
Well, my Lord, I don't. That's no part of my case that they should be construed against termination. It's my case that they should be construed in accordance with the
In
words
favour
that
of
the parties
termination.
selected. Indeed. My Lords, if I may, I'll move on to para 3.6.1, where the Rainwood case and Ferrara Key are referred to by the respondent. And just to make clear what I say and will say in due course about those cases. Those cases concerned an earlier version of the form with different wording. The courts in each case proceeded on the basis that the previous form operated as Providence contends this form operates. The relevance of that is twofold. First, it goes some distance in my submission towards meeting the respondent's case on the uncommerciality of the consequences of the appellant's construction. And second, the previous form and the published guidance and explanation of the changes to the relevant wording are of some assistance when it comes to the interpretation of the provision at hand. I trail those points and I will develop them in due course. There are, I think, 3 points where there is or may be something between the parties on the legal principles to be applied. First is the repudiation point. that I identified a moment ago. The second is the why not say it point.
Sorry, the three different principles. What was the first again?
The repudiation point at paragraph 351 of the Respondent skeleton. Second comes from the body of its
Sorry,
submissions.
the repudiation point.
Which is the point that's being made in paragraph 3.5.1.
Oh, 3.5.1. Sorry, you said 3.1. 3.5.1. Yep,
Sorry.
understand.
The second is the why not say it point, i.e. if the parties had meant X, why didn't they draft differently and say it in terms? The third is the availability of previous versions of the standard form as an aid to construction. So can I just address, please, those points briefly?
There used to be an authority which I was very familiar with once upon a time, and now completely forgotten. It's a judgment of Lord Justice Ricks, where he says you can't really deduce anything from the fact that you've changed availability of previous versions, because you don't know why the change has been made, nor indeed you know, until you just simply have to interpret what the effect of the current wording is. Does that ring a bell?
I think, well, there were two cases that we have in the bundle. One's Lord Justice Aikens and one's Lord Justice Morbick, I think. It may be one of those because I think those cases make a point in those terms. And in my submission here, as I'll come on to show, we do know why the changes were made. And so it falls within or without, when you look at it, the rubric. If there's a judgment of Lord Justice Ricks, I'm afraid I'm not familiar with it, but can I show you the passages in the cases that we do have, which make that sort of a point in a moment. But my lord, the point is that is right, but the judgment makes clear that there's no bright line exclusion, and that where one knows why, can see why the changes were made, then that's a different category. That's my submission. I'll deal, please, first with the what I've called the repudiation point, articulated at 351.
Well, this starts off in the absence of a contractual right to terminate.
That's the one.
But there is a contractual right to terminate, which is what we're here to determine.
Yes.
So why are we interested in this at all?
Well, my lord, as I understand the point, what's being said, we'll have to then go on to the second sentence. So in that context, it's inherently unlikely that a party would agree to a contractual termination mechanism allowing the other contracting parties to terminate immediately for any reason.
We're not talking about immediately, because we're talking about a repeated default.
Yes. Yes.
At the moment, I don't think, until I hear Mr. Lewis, I don't think paragraph 3.5.1 has anything to do with the particular point that we're here to decide. In the interest of getting to the issues, perhaps we could put the first of those 3 points at least on hold.
I'm grateful, my lord. The second is the why not say it point.
Yeah.
I'll address the particular points on clause 894 in a moment when we come to the wording. As regards the point of principle, we say it's rarely helpful to consider what alternative formulations the draftsman could have used. There's no absolute prohibition on that. It really depends on the particular provisions at hand. But in terms of the guidance available to the court, I won't go through it, but you have within the authorities bundle at tab 5, pages 79 and following, the relevant section from Lewison. I see my lord's turned it up, so
He says it's the weakest argument of construction you can possibly advance, isn't he? More or less.
that is yes. In a sense, it's seldom helpful. And what one has over the course of the following 3 pages is, well, footnote 347 cites a number of cases in which this section of Lewison has been approved by the courts, cited with approval. You have Lady Justice Aspin, or Justice Mansfield, Dunedin, or Justice Lawrence Collins, Lord Hoffman, Lord Newburgh, and Lord Justice Simon, all making the point in terms that it's rarely helpful because both parties could play that game. It doesn't take you very much further. There's then one paragraph at 2.114 on page 82 of the bundle. It says, however, the argument that if the draftsman, after all of that, if the draftsman had meant he could have easily said so, does sometimes find favour. 358 is a footnote with two cases cited, and it's those two cases that the respondents put into the bundle. And the point that I make is, well, if the proposition that's going to be made is that, well, sometimes it is of some assistance, well, yes, maybe, but in pretty rare cases. And actually, we say here, if it goes in either direction, it goes in the appellant's favour. And perhaps that's better addressed when we come on to look at the words in a moment.
But you agree it's not an absolute prohibition, so it's a matter for us.
Absolutely. Then the third point, the previous versions of the standard form, and I'm addressing here the point of principle. It's said on behalf of the respondent that previous versions are inadmissible, but there's no authority cited. So can I show my lords, I hope this answers the point that was made by my Lord or Justice Stuart-Smith a moment ago, the two cases, which are, I think, the cases cited in Lewison on the point. The first is the Seadrill and Gazprom case, which you'll find in the authorities bundle behind tab 14. This is a case about the construction of the indemnity provisions in an offshore drilling contract on the IDCO form. I won't go through the facts unless that would be helpful, but if we go please to page 172, paragraph 17, and this is the fullest passage that we have in the bundle. So paragraph 17, parties in the judge were content to treat the history and development of the IDCO form as part of the commercial background to the contract, and this in cases where it's possible to identify with a degree of confidence the reason for a particular amendment to the standard form. And then there's an example where a change has been made to respond to the effect of a particular decision of the courts, change in legislation or a widely publicised event. That may be appropriate. Such cases are usually well known within the industry and are often documented in the trade press. Both parties are likely, therefore, to be aware of them. I'm doubtful, however, whether it's legitimate simply to compare the earlier and later versions of the contract form on the assumption that the parties consciously intended to achieve a particular result by adopting the later version. Such an exercise is not wholly removed from that of referring to drafts produced during the course of negotiations, which are not a proper way to construction. And then there's a why didn't they say it type point comes up. The earlier version does, of course, serve as an example of how the contract could have been worded differently. In respect, it has no greater persuasive force than a text created for the purposes of trial. And then again, the fact is that in the present case we have no evidence of why specific changes were made, or any evidence that parties turn their minds to the differences. And so that, my Lord, that may be the passage that my Lord was thinking of, and if it's not, it sounds very similar. And the other case that we have is the REWA, which you'll find behind the next tab, tab 15. For the relevant paragraph, you will find on page 190, the bundle page numbering. It's paragraph 30 of the judgment. As already noted, Mr Kelly wished us to look at the previous version of the standard NSF terms and to look at the BIMCO Drafting Committee's commentary as a construction, whilst there may be occasions when this has to be done in order to assist in solving the problem of ambiguous wording. I would generally discourage such exercises in the archaeology of the forms. In most cases, it makes the task of interpretation of contractual wording unnecessarily over-elaborate, and it can add to the expense and time taken in litigating what should be short points of construction. So, practical, in a sense, warning, principle. And here, in short, my submissions are: first, we know what the previous versions of the form said; second, their meaning was well known and had been the subject of decisions by the courts; and then third, there is evidence as to why the changes in the form were made, viz. Abbreviation, how they were treated by the commentators, and therefore that they were not intended to make the fundamental changes contended for by the respondent. And I'll seek to make that good at the end of my submissions. My Lords, may I turn, please, to the wording of the contract? And if you'd be good enough to go to tab 11 of the core bundle at page 89, or supplemental bundle tab 5, pages 84 to 85, you'll find 894. And we've been through the structure of the clause before. 891 identifies the defaults. If compliant notice is given, that type of default then becomes a specified default. 892, qualifying events of suspension might become specified suspension events. 893, termination for continued specified default or suspension. And 894, termination for repeated specified default or suspension. Now that latter, that 894 right to terminate for repeated specified default, arises where the employer repeats a specified default, whether previously repeated or not, and termination notice must be served within 28 days of the repetition. The case against me is that there is in effect a condition precedent to that right arising, to the effect that there must have been a prior right under 893 that was not exercised. That is taken from the words, if the contractor for any reason does not give the further notice referred to in clause 8.9.3. We say that does not stipulate that the right to terminate under 894 is conditional upon a right having previously existed under 893. That is not what the words say. Rather, those words describe a state of affairs, i.e. no notice under clause 8.9.3 has been given, and make clear that that state of affairs can have arisen for any reason. One reason for that state of affairs might be that the original specified default was ended by the employer within the cure period of 28 days. There is nothing in the introductory wording of clause 894 excluding that reason from the list of reasons as to why the contractor might not have given the notice under 893. And if one is going to say that some reasons for the state of affairs qualify so as to give rise to the right to terminate, but some do not, it is critical that those are delineated and spelled out in clear terms. that is because it is very important that a contractor and indeed an employer can look at the strict wording of a termination provision and determine from that whether, in the circumstances at hand, it is entitled to terminate. And here we have the words "for any reason." And in my submission, the questions that a terminating party will ask itself are, number one, here, have I given the further notice under 893? We'll answer that no in this case. And second, am I entitled to serve notice under 894, given the reasons for my not having served notice under 893? The contractor will then have regard to the words "for any reason" and conclude that it can serve termination notice under 894 where the specified default has been repeated, subject always to the 821 proviso that notice isn't to be served unreasonably or vexatiously. Now, the respondent, my lords, contends that the words at hand both presuppose the existence of a prior right and refer back to the contractor's discretion under 893, which it could choose to exercise or not. And just for my lord's notes, that's respondent skeleton paragraphs 4.2 to 4.3, to which we say, there is nothing in the language to the effect that a prior right must have arisen. The words say nothing of a choice having been made, but they are certainly broad enough to cover a situation where the contractor had the right but chose not to exercise it. And that, we say, is important. By using these words in 894, the JCT and by extension the parties do make clear that the contractor can obtain and exercise a right to terminate under 894, even if they had had a right under 893 but chose not to exercise it. These words in 894 put that, in my submission, beyond doubt. But what the words do not do is limit the availability of clause 894 to that scenario, or otherwise exclude the present scenario where the default had been ended within the cure period for the purposes of 893. And that, we say, my lords, is part of the answer to paragraph 4.5.1 of the respondent's skeleton argument, which you will find at page 49 behind tab 4. So paragraph 451 says the draftsman could have simply started with the words If the employer repeats a specified default, then the contractor may terminate its employment under this contract. Those words would operate as Providence says Clause 894 operates. It would do so unambiguously. The fact that the draftsman chose not to adopt this simple and clear formula strongly suggests that Clause 894 was not intended to operate as Providence contends. We say the following in response to that, picking up the point I was making a moment ago. First, that might be a different way of achieving the effect for which we contend, but it is not the only way. The words actually used extend to the present circumstance. Second, the words actually used serve to make clear that a failure to exercise a right under 893 will not prevent a right under 894 from arising. Third, here and in the subparagraphs surrounding 451, the respondent is essentially making a why not say it point, to which we say, first, that's not a helpful approach here, at least for the respondent. Second, the words actually used do comprehend the present circumstance, where the specified default was cured before the right arose. Third, suggestion...
Sorry, what was your second point?
The words actually used do comprehend the present circumstance, where the specified default was cured before the right under 893 arose.
And that's concentrating simply on the word any. For any reason includes there was never a right to do so.
Yes.
That's
indeed.
your case.
Indeed. Indeed. Third point on this, at 441, there's a suggestion that the draftsman would have needed to say does not or cannot serve the notice under 893. So it does not give is not enough. It had to have said does not or cannot in order to achieve the effect that the appellant contends for. We respectfully say that's wrong, because cannot is within for any reason, and does not refers to a factual situation. And then fourth, if the draftsman had wanted to exclude the present circumstance from 894, then additional words would have been required so as to qualify for any reason.
It's a little bit more than a why not say it point, isn't it? It's essentially a point on the whole introductory language being odious and unnecessary. And I know that there are authorities which suggest that the presumption against superfluity doesn't always have any great weight, may have greater or lesser weight. I think the point that's put against you is it means what you said it means. All that language is completely unnecessary.
My Lord, it isn't. And first of all, it's a form of words that covers all situations, number one. Number two, directly on the superfluous point.
I'm not sure I understand that one. If it in fact said simply if the employer repeats a specified default, how would that have any different consequences from the way you say the words operate?
Well, if that were the case before the court, then it might be submitted that actually the result was the same as the result for which I contend here.
That's the point that's being put against you. You get the same result, you don't need all those words.
Indeed, but what those words do serve to make clear is that if one has issued a notice of specified default and then not followed through on it, and in effect allowed it to lapse even though a right arose under 893, then that's not going to prejudice your right under 894 where the default's repeated.
But that doesn't work because the mere fact that you had a clause saying if you repeat then you can serve an 894 notice demonstrates that the presence or absence of an 893 notice doesn't matter.
But that's why I say, my lord, that if the wording was as suggested, then the result would be, as I contend for, except that my submission then would be that yes, I would be on the right side of the question. But what the draftsman has done here is chosen a form of words that makes explicit that which in that case may otherwise be implicit, which is that the rights are separate and in any circumstance where there is a repetition of a specified default, then the right arises. This is not by any means beyond the realms of possibility that contracting parties in the industry might wonder what the consequence of allowing termination rights to lapse might be. So a form of words that comprehends all scenarios and makes explicit that the lapse of an 893 right will not, in effect, prejudice reliance upon the earlier notice of specified default serves some purpose. Maybe strictly unnecessary. It can't be said to be entirely without purpose or logic. But fundamentally, in my submission, what one has to do is read in accordance with its ordinary language and meaning the words that the parties did choose.
Can I ask you about something else that's just troubling me slightly? What happens if you have given an 8.9.3 notice, but actually there's a dispute about whether you're entitled to do that, and therefore whether that has had the effect of terminating? Obviously, if it's terminated, you don't need 8.9.4. But suppose that you've had a dispute about whether you were entitled to serve the 8.9.1 notice. Maybe it's 3.16 compliance with CDM regulations. You serve an 8.9.3 notice. Does that mean that 8.9.4 simply can't arise? You can never rely on that as an alternative?
Well, on the face of the wording, that would be right. One would then have to have the argument under 893, unless the terminating party decided to withdraw the 8.9.3 notice potentially.
Well, but say, sorry.
No, go on.
But say you are then prevented from relying on repeated breaches if there's a dispute about whether you're entitled to serve the first termination. And I'm not suggesting this is a point against you. It just strikes me as a slightly odd consequence on both sides' case.
No, indeed. I suspect the point doesn't help or hinder either of us, and it is an oddity in the wording. I accept that. So whatever view the court takes about that hypothesis, probably doesn't affect the outcome of the appeal. It might be best left for an occasion on which it arises. But in that case, one will be looking at a situation in which the contractor was saying that it had actually terminated. It's right about that or it's wrong about that. If it's right about that, then the right under 894 has fallen away, and if it's wrong, then it hasn't.
Sure, but that's all by reference to the first, let us assume, only breach, whereas actually what 8.9.4 is really concerned with is a second strike, is a repeated breach.
Yes.
Which wouldn't come into play.
Yes.
If
there's been
a previous notice.
I may have misunderstood, but if you served what purported to be an 8.893 notice, and the employer said this is ineffective, isn't your remedy simply to say, fine, well, if it's an invalid, we'll serve an 894 notice, which deals with, on your interpretation, deals with the problem?
Yeah.
But you can't do that because 894 says you haven't given an 893 notice. So if you have, 894 is simply inadequate.
But if the contractor says if the employer says it's not a valid notice, you just bat on as if you haven't. what I was suggesting. But I'm not sure it helps anyway, my suggestion.
Well, if that's the way to deal with the problem, then what 8.9.4 means is if the contractor for any reason does not give a valid 8.9.3 notice. And that then I think harms your construction because it assumes that the condition is addressing itself to whether it could give an 8.9.3 notice.
My submission is that if the 8.9.3 notice has been given, then the contractor has to sit on the 893 notice or withdraw it. So I think that's the answer that I gave my lord. I'm not sure. It's a matter of submission that if one did read it as referring to a valid notice, that it necessarily cuts one way or the other.
Yeah.
I'll just make a further submission on the issue of choice. You've seen this addressed in my appeal skeleton at paragraph 29. You don't need to turn that up. The idea that 894 requires a choice to have been made. It is not what the words say. The words refer to a state of affairs. But then
but the respondent's whole case is not that is what the words say, it's that the words read in their proper context imply. So I don't, at the moment, I mean, although you want to shut the door on them, I don't see what it adds if for you to say that's not what the words say, because it's not that, as I understand it, it's not the respondent's case.
no, forgive me, when I say that's not what the words say, one should understand that as being a submission that if the parties wanted to achieve that goal, they would have had to, or they ought to have specified it, given the significance of the right at hand and given the importance of giving the words their plain and ordinary meaning. But on the implication point, it would be, in a sense, slightly odd to imply that this required a choice to have been made in circumstances whereby the notice might not have been given due to inadvertence or accident. So if the contractor took his eye off the ball and didn't realise that the right had arisen and didn't serve the notice, it might be odd to exclude that circumstance. Similarly, suppose that the contractor was on his way to the employer's office to give notice and was hit by a bus and woke up in hospital 3 days later, having missed the deadline. It'd be odd, again, in my submission, if that unhappy scenario was excluded. It just goes too far to say that this must mean choice. Some submissions are made at paragraphs 4.6 to 4.8 of the respondent's skeleton. It's pages 50 to 51 of the bundle. About the operation of clause 894 in context. At least to some degree, those paragraphs comprise assertions as to how the provisions work on the premise that the respondent is correct, rather than providing reasons as to why the construction is to be preferred, you say. But can I please pick up some of the particular points that are made and respond to those? So at 4.8, my lords, this is on page 51, it said that the right to terminate upon repetition of a specified default is a swift and severe consequence, that it makes sense that it should only arise where there's been a prior right to terminate a continued specified default. We say that's, with respect to non sequitur, it is indeed a swift and severe consequence. It is. But, one, it only arises in circumstances where the employer has failed more than once to perform an obligation that the JCT and the parties have stipulated as being particularly important in engaging termination rights. Second, it only arises where the contractor has properly served a notice of specified default, so unequivocally placing the employer on notice and subject to a clear warning that it must not so default again or be at risk of termination. And third, it's always subject to the 821 proviso that notice of termination must not be given unreasonably or vexatiously. And that then links into the contention at 4.8.2, the respondent's skeleton, that the specified default being remedied within the cure period means that the notice has served its purpose, and that there's therefore no reason why the sword of Damocles should hang over the employer's head. Well, as to that, we say, clearly it would be hoped.
Sorry? Clearly what?
Clearly it would be hoped that a notice of specified default would provoke the employer to pay the outstanding sums that are due on that certificate, and in respect of which it's failed to pay by the final date for payment. But that is not the only purpose of the notice. It serves also as a first precondition to the exercise of termination rights under 893 and or 894. And that makes sense, because as the cases we'll come on to have noted, the employer skates on thin ice once a notice of specified default has been served, and he must then be much more careful to pay what is due by the final date for payment. That could, of course, be extremely important to the contractor, who's entitled to expect the employer to comply with its obligations. The notice of specified default will ensure that the employer does so or takes a significant risk. And of course, if there's a minor or excusable non-compliance thereafter, then it may not be reasonable for notice of termination to follow, but that will depend upon the facts. And so drawing that together, my lords, it's not just a question of getting the payment at hand paid, but it serves to incentivise the employer to avoid any further default of that sort. It's, in a sense, it's the yellow card being issued. So if the centre-back puts in a horrendous tackle in the 5th minute and gets a yellow card, then he's on notice for the rest of the game. Do it again and you're off. My lords, whilst I'm considering the operation of the clause, I make one, I think, further point that arises as a consequence of the respondent's construction. So on the respondent's case, clause 894 only operates where there had been a prior right under 893. The ending of a specified default within the 28-day period is not the only reason as to why there might have been no right under 893. It might have been that it would have been unreasonable or vexatious to serve a termination notice under 893. As 821 applies to termination notices generally, not just 894 termination notices. So that's another area of potential dispute, and another factor for the contractor to consider on the respondent's case. On the respondent's case, in deciding whether to serve a notice under 894 in the event of repetition of a specified default, the contractor would also have to look back and decide whether, when not only did the 893 scenario arise in terms of missed payment dates and failure to rectify by cure period, but also would it have been unreasonable or vexatious to serve the 893 notice? And that could relate to a situation that had pertained months or conceivably years prior.
But forgive me, there's no compelling reason why your precondition should be payment within the further 28 days or payment outside the 28 days. It's just a contractual provision. And you can say they're both very serious and cash flow is the lifeblood of the construction industry and so on and so forth. But there's no compelling reason for choosing one or the other, is there?
Forgive me, my lord. One or other being
maybe I'm taking a completely false point. If you serve a specified default notice, you then have 28 days, the employer has 28 days within which to pay in order to avoid the risk of an 893 notice.
Yes.
Okay? The employer is already seriously in default. It's very important that cash flow should be maintained. And so on days 1 to 28, the situation is serious. And one could say that's a satisfactory precondition for if there's a repetition termination. But one could equally say, well, actually we haven't put the marker there as a matter of commercial judgment or talking about commercial consequences, because what really matters is if they go beyond 28 days before they pay, and that does trigger an 893, the ability to give an 893 notice, then if you've gone that extra step, then there's the justification for terminating if you have any repetition, big, small, indifferent, good, bad or ugly. What I'm struggling with is you're addressing commercial arguments and about how this is difficult and that's difficult. At the moment, rather like the judge who didn't place much store on these things, at the moment I'm in the position where I can't see any compelling reason why, as a matter of commercial reality or commercial consequence, that the line in the sand should have been more than 28 days or within the 28-day period. It just seems to me it could have been either. One's more favourable to the employer than the other, that's all.
Well, not actually, although there is, as one would often have, overlap between the two. I haven't addressed you yet on the commercial consequences.
Okay, well maybe I misunderstood what you were saying.
But, no, but to take that point on, this is something we'll come on to. One has to bear in mind what the mischief is, we say, in respect of each of these provisions. So 893 is dealing with the situation in which there is a continuation, time-related default. It goes beyond the limits that the parties have selected as being acceptable in respect of any payment. 894 is dealing with the issue of repetition. That's the mischief. And so it may be, and there is a degree potentially of artifice or choice around the 28-day limit for the purposes of 893. But the consequence of the Lord Judge's construction and the Respondent's construction is that payments could be late on each and every occasion. Very late. And we're talking, one has the due date, then the final date for payment, and then there would have to be the service of notice of specified default, and then there's the cure period. So the payments could be extremely late on every occasion, but provided that they don't stray beyond the 28 days, then there would be no right to terminate, which we say have potentially very serious consequences for the contractor, if that was the way that one approached it. And at the very least, even if the employer didn't run it down to the line on each and every occasion, that lack of predictability and certainty could have very serious consequences for a contractor trying to manage a project and manage its cash flow. So we say that when one thinks about it in terms of what the mischief is and the consequences in that regard, then it does speak in favour of the appellant's construction. And actually it's a point that we make, that to say that actually this response to the problem of repetition is there, but it only comes into play, it only ever arises if on one occasion the contractor has, the employer has strayed beyond the selected 28-day period. We say is a less commercial construction than ours.
Essentially, you say it's undoubtedly, on the case against you, 2 strikes and you're out if you've gone to day 29 first time.
Yes.
It would be odd if it weren't, if you'd only gone to day 27.
Yes. I ally that point with a consideration as to the purpose and the mischief that's being addressed by each of these provisions, and the scope for the mischief going unaddressed on the one construction as opposed to the other. Just finally, my lords, on wording, there's the assistance that might be derived from 843, which is the employer's concomitant right for terminate for repeated specified default. That's at page 88 of the bundle.
Yeah.
And so here, the structure of the clause is materially the same. There's no, in effect, 892, which deals with specified suspension events, isn't there, because suspension is under 8411 as a specified default. But then one has 842, which is the equivalent of 893, and 843, which is the equivalent of 894. And the wording of 843 is largely identical to the wording of 894. The difference being that there is no, for any reason, but there is instead the words in parenthesis after clause 842. There is instead whether as a result of the ending of any specified default or otherwise.
Does it matter where that comes in the sentence?
In my submission, no,
Why not?
because it's of the same effect.
And each on your submission is simply clarifying that there are no exceptions.
Yes, that's right.
So you could, if you bear that in mind, you could then read the sentence. If the contractor does not give the further notice referred to in clause 893, but there's a repetition. Because there are no exceptions.
There are no exceptions.
But, okay, right, thank you.
I
So
may have
sorry,
misunderstood
go
my lord's point. But
So the words "does not give" are the same. So if we read "does not give" as suggesting that there's some sort of implied right to give, in other words, that the situation must have arisen, because they're the same words, then whether as a result of the ending of any specified default or otherwise plays for any reason. And your submission is that they have the same effect.
they have the same effect. So my submission is that it does not give. It's just describing what is it either has happened or it hasn't. And then one has to look elsewhere for what are the circumstances in which does not give has arisen. And in 893, it's for any reason, and in 843, it's whether as a result of the ending of any specified default or otherwise. But what?
So if the respondents are right, we would be looking at the same words but giving them a different interpretation that does not give those three words.
If the respondents are right, then you'd be giving them...
You would be giving it a different interpretation in 894, because that carries with it, they say, the implied right to give a notice in the first place under 893.
There would be a distinction between the two, potentially, yes. But what 843 does is it draws out of, for any reason, the specific point at hand, whether as a result of the ending of any specified default or otherwise. And so makes clear that one of the reasons why the counterparty does not give can be the ending of the specified default. In my submission, lends support to the proposition that does not give is to be construed, as I say, which is as describing the factual state of affairs.
So have I understood you essentially to be making 2 points? One is that in 8.9.4, the construction that's put against you is that does not give means could but does not give. But that is not a meaning to which the very same words in 8.4.3 could be given, and it's a presumption that the same words are used to mean the same thing in the same context.
Yes.
That's 1 point.
That's 1 point.
And then are you also making the point that insofar as there's an argument on 8.9.4 of superfluity, then the same would equally apply to 8.4.3, and yet 8.4.3 can't bear the interpretation that's put against you, so that a superfluity argument isn't going to have any weight. Is that?
There are, I think, a series of points that are made by the respondent on this. I'll just try and knock those off. You'll find this at page 55 of the bundle, paragraph 5.12. So 5.12.1 suggests caution and notes that the grounds for termination are different as between the employer and the contractor, to which we say, my lords have the point. Corresponding clause is using a very similar formulation. One ought to have regard to the surrounding provisions of a contract when construing a provision. And then whilst the grounds of termination do differ, there is overlap. It's worth bringing that point out. So on the unamended JCT form, 2 of the 3 contractor grounds are also employer grounds. One here has been deleted by amendment.
Where are you?
I'm in 5.12.1 of the respondent's skeleton, my lord. Then 5.12.2, it said that the words are different, with which we agree. We say not materially. And then one has to look at the difference in the wording for any reason, clearly comprehends whether as a result of the ending of any specified default or otherwise.
I mean, your point is that means for any reason. That was the point I put to you before.
Indeed.
Or it has the same effect.
Does.
Yeah.
And then 5.12.3 said Providence's analysis proceeds on the assumed basis that properly construed clause 8.4 means that a right of termination for repeated specified default arises even when specified default had ended before the right of termination had arisen. However, that assumption is not correct, because a specified default can have ended following the right of termination having arisen. So that's, as I understand it, the point where the end of the specified default occurs after the cure period, 14 days, but before the expiry of the 21 days within which notice can be served. I think that's the point that's being made. To which we say, well, yes, this provision clearly covers that scenario, but it's not limited to that scenario. So it's another point about the reading limits into the wording that's been used without any need to do so. And that's productive of uncertainty and so on. And then finally, 5.12.4. There is, in fact, Roman 1. Different wordings being used, giving rise to an inference that the difference is intentional. Well, one shouldn't proceed on the basis that the words there therefore necessarily mean something else. You have my point that they don't mean something different. One actually has to look at the words. Rather than just assume that because they're different, they mean something different. Actually, what do the words mean? And then in respect of symmetry, which is the point at Roman 2, we agree. The parties can contract on whatever terms they wish. But notably here, there is overlap between the grounds, and I've covered that. There's nothing, in a wider sense, there's nothing in any textbook, case or guidance to suggest that there is a difference in the way that the employer termination provision and the contractor termination provision are to be approached, nor that that was introduced when this wording changed in the 2005 form, and that would almost certainly have elicited comment if such a distinction was introduced. And indeed, learned friend, I think, invites your attention to the JCT guide to the 2016 form, which you will see treats the party's termination rights as, in effect, coterminous so far as the procedure goes. And my lords, I'm going to make some submissions about the iterative process. Try to take those quickly. We've already touched on some of them. Conscious that I have failed to satisfy the court's invitation to make sure this case is heard in half a day. The first and primary point on the iterative process, I'm taking this slightly out of the sequence in my skeleton. In the skeleton, I think I dealt with the appellant's construction first. I'm here dealing with the respondent's position first. So this is paragraphs, in case my lords are making notes, 44 and following of my skeleton, in case it's being used as a guide. My first and primary position point on the iterative process is the point I made to my lord a moment ago. The respondent's construction would expose a contractor such as Providence to a situation where the employer had up to 28 days after the service of the notice of specified default, which would itself only follow after the final date for payment, before the contractor could obtain any right to terminate. And that would pertain in respect of each and every payment cycle. At the extreme, in every payment cycle, the employer could take 27 days beyond the service of a notice of specified default. Short of that, the payment position could at the very least become very unpredictable for the contractor. Why does that matter? Well, the obvious reasons: management of cash flow, consequent ability to fund its operations, payment of staff, purchase of materials, payment of subcontractors, payment of creditors. For your notes, I've set some of these out at paragraph 46 of the appeal skeleton. And we say reliable cash flow for a
Well,
contractor
it's the
being
lifeblood of the industry.
indeed absolutely
Or
vital.
at least it was when I was at the bar, as I recall it. So I think we can
Hasn't changed.
take that as read.
Yeah.
Hasn't changed.
And second, it's very important to a contractor that where an employer has proved itself unwilling or unable to satisfy the important obligation to pay the sums due and timelessly, it can extricate itself from that contract. Third, the point I made a moment ago in response to my Lord Justice Stuart-Smith, we respectfully say it's important to remember that this provision 894 on our side and 843 on the employer side relates to termination for repeated default of a number of specified obligations. That's the mischief. On the respondent's approach, the employer can repeat specified default as many times as it wants, provided it never strays over the 28-day cure period. And we say that does not address the mischief to which these termination rights are justifiably directed. In terms of the counterpoint to this, the remedies that the contractor does have, adjudication, we say, can be disposed of quite shortly, because if the employer is paying within 28 days of the notice of specified default, there'll be no point in adjudicating, even to the shortest time frame. Second, interest may or may not cover all of the financial consequences of repeated late payment. Suppose that over time relationships between contractor and its subcontractors, suppliers deteriorate.
Under the contract, when does interest get paid?
I'm sorry, my lord.
So if the employer is 27 days late, or 27 after the final date, speaking entirely for myself, I haven't looked at the provisions for interest. So two questions arise. Does final date plus 27 days carry a right to interest? If so, where? And second, if so, when? This all goes to your point about it not being sufficiently immediate.
Well, I'll have to come back with those references.
Okay.
But the key point that I make is even if interest did kick in for that
Yeah, we've got
period,
that.
there are all sorts of problems for which it's not going to be any sort of a remedy. And in a practical sense, the exposure of the employer to a certain measure of interest on interim certificates is not going to disincentivize the employer, and it's not going to help the contractor to manage supply chain. And then finally, suspension. That is an important right, but one that we say is not well suited to repeated late payments. Repeated suspensions will lead to a thoroughly chaotic project and come at a significant management difficulty to the contractor. There's a point made by the respondent that I'll give you the reference, but we don't need to turn it up. It's 4.12 of the respondent's skeleton, to the effect that it would be odd if it was easier to suspend than, easier to terminate than to suspend. And it's important in that regard to bear in mind that 894 concerns repeated specified default in respect of various obligations, whereas the right under 4.11 to suspend concerns any default in respect of the payment obligation alone. So it's only when there has been a repeated default that termination can arise immediately, whereas there is a 7-day period for suspension. So it's a slightly false comparison. And second, it's wrong to treat the contract, which is I think implicit within the submission, wrong to treat the contract as if the draftsman had an entirely free hand. Because as you'll see from section 112 of the Construction Act, which you have in the authorities bundle, tab 17, page 209, subsection 2 requires there to be 7 days notice for a suspension. So in a sense, the JCT had to draft 4.11 right in the terms in which it did. It has long been the case under the JCT forms that one could terminate on repeat of specified default.
Could you just give me the page for that?
Yes, that's Authorities Bundle, tab 17, page 209. It's section 112 of the construction. Concerns the right to suspend a non-payment. And section 112.2 stipulates that the right may not be exercised without first giving to the party in default at least 7 days' notice of intention to suspend performance, stating the ground or grounds on which it's intended to suspend performance.
So the 7 days notice, 7 days before you can give notice, and then clause 411.1 says you can only suspend 7 days after that.
Yes, it mirrors the Act.
Yeah. Okay, yes, the 7 days in 411.1 and section 112.2 are the same 7 days.
Yes.
Okay, yeah, thanks. Sorry, I misunderstood.
It's said against me that my construction, or rather the respondent's construction, can't be uncommercial, given that it involves largely restricting Providence to the rights that it's given by the Act in terms of interest suspension adjudication. As I've already made clear, I don't say that their construction is uncommercial, I say it's less commercial. And furthermore, Section 112 makes clear that those rights are without prejudice to such other rights as the contractor may have. And B, that Parliament didn't see fit to intervene in the party's freedom of contract further and mandate a right to terminate. It might be thought not to be surprising. Parliament did introduce these rights in the context of a long-standing set of JCT forms that did entitle the contractor to terminate a repeated specified default in precisely the way that I contend for now. I don't think the point doesn't go very far. Turning, if I may, to the appellant's consequences of my construction, the key point made against me and that the learned judge below accepted was that payment made a few days late, that after a notice of specified default would lead to an immediate termination if the employer ever subsequently underpaid or missed a payment date again. See, for example, para 4.10 of the respondent's skeleton, to which our answer is that there is the unreasonable or vexatious proviso. That was regarded below as tricky or nebulous. And that is, that distaste is maintained, as I understand it, by the respondent on this appeal.
Why would it be vexatious if that's what the contract expressly permits you to do?
Well, there are two things. The vexatious provision is authority to the effect that vexatious means intended to harass or annoy, which will go to motive and could arise in certain scenarios.
And how would that arise? How would that arise
if
they were a day late twice? Why could it be said you were intending to harass them as opposed to, no, we're simply trying to exercise the contractual rights which the parties have agreed we should have?
Mm-hmm. But I'm not aware of any cases in which it's been found that the service of termination notice was vexatious.
No,
but in terms of...
Well, that's what I'm putting to you, that it's not actually much of a protection against what's put against you as the uncommercial consequences of your construction, to say, well, if the employer's paid 12 hours late twice, well, you would be prevented from standing on your contractual rights, on your construction, by the vexatious proviso. I'm not sure why you would.
Well, my lord, the vexatious proviso, it covers really a pretty narrow compass.
Yes,
It looks to motive. It's the unreasonable element.
Oh, I see. Sorry, I was using unreasonable vexatious as a vexatious for all of it. My fault.
Yeah.
Unreasonable, but why is it unreasonable for you to stand on your contractual rights?
Well, my lord,
It didn't seem to me the authorities left much scope for that.
my lord, it will be in those cases
Yes.
where there are a series of factors that the courts have looked at in terms of what comprises unreasonableness. But if there was a minimal or technical default with little consequence, for example, then that might take the case towards the unreasonable end of the spectrum, just the sort of extreme case that's being put against me as meaning that my construction can't be right. And that's how it's been approached. It was unequivocally the case in the prior version of the standard form. I say that's simply maintained. We'll have a look at one or two of the cases in a moment, but the courts have had to wrestle with unreasonableness on a number of occasions over the years and haven't had too much difficulty in adumbrating a series of principles. There's doubt over whether, for example, the proportionality of the response to the scenario is something to be taken into account. But I think the 5 other principles are present and correct on any view. So, I mean, it's a fact-sensitive question, as these things often are. In a circumstance in which there have been repeated defaults, it's not just a one-off, that the sums involved are substantial.
That's not the point we're on.
The
point we're on is you're seeking to meet the apparent uncommerciality if we haven't got a large number of large late payments.
Yes. But those extreme cases.
The contrary.
Indeed, but it's those extreme cases where there haven't been a large number, where we're talking about pence or a day, that it may be considered unreasonable to exercise the right to terminate. So it takes those extreme or soft examples out off the table. So that would be the argument. And but this is the proviso. This is on any view. This is what the parties.
This is neutral anyway, because what we're arguing about is the need for a prior default to have gone beyond 28 days or not. It says nothing about the second default. The repetition of the default could be £5 or half an hour or whatever. So that issue is going to arise anyway.
Yes.
Or it is there for contemplation.
It's there on my case. It's there for the 894 notice.
But on anybody's case, it's on anybody's case. The second, if the first hurdle is crossed in relation to the first default, whatever the hurdle may be, then 2 pence or 10 minutes and you're out.
That's right. Observe that on the respondent's case, it arises twice, because you have to consider it in respect of the putative or the potential 893 notice that was not served, to check that you had the right to serve that in the first place, and also in the 894 notice with which you are, as a contractor, presently concerned with, which is an oddity in my submission about the respondent's approach, insofar as it's going to say that one should not place too much store by unreasonable vexatious. You have to get into that debate twice. But just in direct answer to my lord's question, there will be scenarios in which it's unreasonable to exercise those strict rights. It's fact sensitive. There are a series of considerations that have been set out by in the authorities as to what to take into account. But it is a valuable protection.
We've got a nice illustration of that, because both your letters were written the day that the complaint of which you made arose. So the final date for payment of the first one was 15th of December, and you wrote on 16th. And the final date for the other one was the day before the 18th of May, I think, unless I've mistaken it. But anyway, it's a clear demonstration that parties to construction contracts keep their lawyers close. Yeah.
My lords, the earlier authorities touched on this point, the proposition that the approach that the appellant takes to the construction of this particular provision is defies common sense. We say it's hard to maintain in circumstances whereby the previous version of the form unequivocally had the effect for which we contend and has been considered by the courts on a number of occasions and the commentators without any apparent disquiet concern, with the commentators and the courts simply observing seriousness under these forms of contract of repeated late payments. And one can see that when one looks at the previous form and the cases on it. I'm conscious of the time. I don't want to...
Okay, carry on. We're not going to finish at lunchtime now, so
Can you give us
these cases expand to fill the time made available. If I'd said half a day, when I estimated the time when I gave permission, you'd have done it in half a day. There it is. So what are we looking at now?
My lord, the 1998 form, which you'll find in the supplemental bundle, tab 3, page 5. And if you'd be good enough, please, to go to page 6. I think in the electronic version will be now page 10, or the PDF.
Sorry, give me the reference again.
So supplemental bundle tab 3.
Oh, supplemental, sorry. It was in the authorities. Supplemental 3 by page
6. This is the predecessor drafting in the 98 form. We're looking here at clause 28. And 28.2.1, we've got the equivalent to 8.9.1 with the particular sorts of defaults, which are, I think, the same, potentially giving rise to a notice of specified default. 28.2.2 over the page sets out suspension events. Then 28.2.3 is the right to terminate for continued specified default. Much the same form as we see it in the current form. And then 28.2.4, if the employer ends the specified default or defaults, or suspension events cease, or the contractor does not give the further notice referred to in 28.2.3, and the employer repeats specified default, then upon or within a reasonable time, the contractor may determine. And then over the page at 28.2.5, the notice of determination should not be given unreasonably or vexatiously.
But the same question arises, whether the phrase "the contractor does not give the further notice" referred to in clause 28.2.3 implies that he could do.
Well, it's dealt with differently in this clause, my lord. So the ending of the specified default or contractor doesn't give the notice means that it really doesn't in this case mean that, because this clause brings in, indeed, it brings in.
I think your case is, the effect of this is the same as you contend in the current version. But the point that's being put to you is that that's because you've got the two first bullet points here, and the equivalent phrase the contractor does not give the further notice only needs to cover cases where it is entitled to.
Yes, agreed.
So,
Yes.
in the new version, you've got imported language which meant what's put against you, although effect is
Different, we say.
You say
because
different.
what they've done is they've taken out the employer ends the specified default or defaults and included the words for any reason. That's what they've done.
Yes.
In order to achieve that end, and that's why, and that's described as abbreviation in the guidance, and so on. And if one turns, please, to the authorities bundle, tab 2. You'll find page 18, Raymond and Brown.
Sorry, tab which?
Tab 2, my lord.
Thank you.
Starts at page 18.
Thank you.
Got here the case that first column you can see is on the JCT 98 form that we've just been looking at. Towards the bottom of the first column, defendant left site having purportedly determined the contract under 2824 on the basis the claimant had repeated a specified default. And then the initial specified default one gets from the second column towards the top, followed an initial notice of specified default in the January 2006, where you look at the passage where the effect of the judgment is given, paragraph 1. The January 2006 notice was a valid notice. Claimant was in default, failing to pay that sum due on 25th of January and certificate 29, some not having been paid until the 1st of February. And what one has here is a case in which the initial specified default had occurred, it had been cured within the cure period, and then there'd been a repeated default and that founded the termination. And this case went all the way up to the House of Lords. It went on the point as to the validity of the initial notice of specified default. So at each stage, the courts proceeded on the basis that a specified default that was cured, so no right under the equivalent of 893, and when it was repeated, the immediate right to termination arose. My lords, you might find the commentary over the page at 19 instructive. And I won't go through it all, but I invite the court's attention to it. I pick up just a couple of points that are made here, please. The second column, the end of the first paragraph, the editors of the law reports are saying there's no reason even why payment should not be made prior to the due date. These payments don't have to be made on the latest day simply as a matter of course. So it is of course, it's paid by the due date, if not paid by the final date for payment, then there's a notice of specified default and a cure period. So by the time these things get that far, they are serious breaches on any view. And then there was a point taken here that the termination notice could only be served after a reasonable period, not immediately. We said that was an implied term and that proposition was rejected. Then just towards the bottom of this paragraph, plainly would not be necessary for business efficacy, save for those running businesses who could be said not to have taken the initial default sufficiently seriously. The JCT form does not permit a contractor to determine simply because a single payment is a single day late. However, if an employer has found himself in circumstances where earlier payments were late and the necessary notices have been served, then he's on very thin ice indeed. Further repetitions run the risk that came to pass in this case, namely determination. If one goes, please, to page 29 of the bundle.
Well, this is all of the passage that's sidelined is concerned with unreasonably and vexatiously.
Yes, there are a couple more passages that I invite your attention to, if I may.
Well, I'll tell you which passage I think is relevant, which is not sidelined in a moment. But the sideline, what am I getting from the sideline passages for the purposes of this case?
For the purposes
the meaning of the clause 8.9.3 in a new form?
My lord, the sideline passages relate to the unreasonable or vexatious test,
Yeah.
and it illustrates the court the consideration that that's been given to that proviso over a number of years, and the way in which it's to be approached and the guidance that's been given. And it's in answer to the point that this is somehow tricky and nebulous and ought to be relied upon as a check on a contractor's right to terminate too easily on my construction, which I say, no, you've got this proviso, it's been considered over the years, and here are the cases in which the courts have looked at it, and the principles and guidance that they've given parties who contract on these forms. That's as far as that goes. Further points, my lord, that I wish to draw your attention to are, first of all, on page 29 of the report, in the second column, picking it up about 6 lines down. Clause 2824 is, in my judgment, clear and unambiguous, and it provides that a notice of determination may be given as soon as the specified default has been repeated. There is nothing unreasonable in that, since the employer has already received a warning in respect of the previous default. It must be taken to know that if he repeats the default, he runs the risk that the contract may be determined either forthwith or within a reasonable time after the repetition of the specified default, which is a point that I would make in respect of my construction of this form. And then page 31, paragraph 40. Picking it up in the second sentence, it should be remembered that under clause 2824, a notice of determination may only be served if the employer has either repeated a breach of contract about which he's previously received a warning, or where the notice of determination has been given under 2823 continued the breach 14 days after being warned. It's clear from 2821 that a failure on the part of the employer promptly to pay the amount due under a certificate is regarded under the contract as a serious breach on the part of the employer, and that the contractor may determine the contract if that breach is repeated, provided only that the contractor is not acting vexatiously or unreasonably. The contractor is entitled to be paid by the due date, and he's not, for example, bound to incur the expense of pursuing other remedies such as adjudication or arbitration to obtain payment that may determine the contract. So again, responding in a sense, or mirroring my response to the criticisms of the effect of my construction in this case. And then at page 37 of the report,
Paragraph 64.
64.
Well, that was the paragraph I highlighted when I was reading this at the end of last week. Yeah.
Great.
I mean, I don't think it says much more than 34 and 40, but it makes a similar point.
Indeed, my lord. Indeed.
Yeah.
I will not take you through the Ferrara Key case unless it would be helpful, on the basis that it is, in a sense, more of the same. It's there to show that the courts have set out statements of principle as to how the unreasonable or vexatious proviso is to be approached. It is necessarily sensitive.
Well, it's a case that arises in a slightly different context because it's concerned with an injunction. But Judge Toolin makes the same skating on thin ice point.
Absolutely. Absolutely, my lord.
Yeah.
Is there any case in which it has been held to be unreasonable to rely on late payment for termination?
I'm not aware of such a case, my lord, but I confess I've not been to all of the earlier cases cited in these two cases that are before the court in order to check as to what the outcome in those cases was. But I'm not aware of a case in which it's been held to be unreasonable. What can one take from all of this? Well, first, the 98 form worked as the appellant contends the 2016 form works. Second, there was no criticism of that in terms of unfairness. Rather, the courts and commentators stressed the importance of the obligation to pay on time and the fact that the employer was on notice once a notice of specified default had been served, so would have to be careful not to default again. Third, that was considered to serve the valuable purpose of ensuring the contractor was paid on time. And fourth, there's certainly no suggestion that the approach taken by the JCT defied common sense, which is what the respondent now says is the effect of such a provision. Can I, my lords, conclude?
So just before you do that, we've been looking at commercial consequences in the context of non-payment, because that's this case, but the clause must mean the same, presumably, if the relevant breach is a failure to comply with clause 3.16, which are the CDM regulations.
Yes.
I'll happily confess I don't know very much about their operation, but would I be right to assume that one might have quite trivial breaches of CDM regulations and a particular aspect of health and safety, so that one wouldn't be having the same arguments as you currently be making about how reasonable it is for the employer to be skating on thin ice in relation to payment because of the importance of the lifeblood.
Conceivably, there will be a different series of issues that arise in respect of CDM or I think the other provision that I think struck out here has to do with assignment, non-assignment. The extent to which there may be trivial breaches of CDM regulations without consequence versus very serious breaches, I can't, I'm afraid, assist the court with. But I would anticipate that there is a range within that. And the point that I make, some of these points about the seriousness of the consequence may not be capable of being made with the same force where the breach is trivial. But first of all, you have the unreasonable or vexatious proviso, really talking about unreasonableness, to cater for those situations. And B, the parties in stipulating that these are the short list of obligations in respect of which notices of specified default and ultimately termination can arise would have been well known to the parties. So the parties will have had in mind there could be a range, but we have chosen the breach of these provisions will be of a very serious character, taken to be of a very serious character, and we have put them into that category and put them into clause 28. And they were the same certainly on the contractor's termination side. We've just seen in the 98 form as they are, 2005 onwards.
Thank you.
Well, that links to the final point, which is the further material available as an aid to construction. We've looked at the 98 form and the understanding that it operated in the way that it operates. The provisions in clause 28 that we were looking at a moment ago have become what we now recognise as clause 8.9 in the 2016 form, and that's been the case since 2005. For your notes, you have the 2005 form in the bundle, I think behind tab 4, pages 15 to 16. Question that may arise is, why did the drafting change? There's no suggestion anywhere, so far as we're aware, that there was any dissatisfaction within the industry with the previous drafting. Rather, the published guidance that came from the JCT to its users explained it as abbreviation. Could we please have a quick look at that? You'll find it in the authorities bundle behind tab 8. Page 114, you've got the cover page. And if we could go on, please, to page 117 in the introduction. Para 1, part 1 of this guide gives a brief overview of the 2005 edition of the JCT Design and Build contract, including its main features and points of difference from the JCT standard form of building contract with contractor's design, that's the 98 form. Part 2 then contains a more detailed consideration of the provisions of DB 2005 with particular emphasis upon those provisions that have altered significantly from those of the 98 form. Over at page 180, part 1, a brief overview, pick it up at para 9. The JCT's intention is that the content of the 2005 form should, as far as possible, be familiar to users of the 98 form. Certain points have been clarified, but there's been no material alteration in risk allocation. And many of the 98 procedures have been retained. Within that framework, the content's been adjusted so as more fully to reflect current needs. Many of the 98 provisions have been simplified and almost all have been abbreviated. And then, under the heading Content, para 11, the following are the principal changes in the content of the contract. And then if you go over the page, please, to 119, pick it up at Roman 9. Certain other provisions have also been revised, notably, it says termination, section 8. Then under the heading Structure, para 14, the conditions consist of 9 sections and 7 schedules. And if we go down, please, to section 8, this is the bit that there's a line next to termination section based on clauses 27, 28 and 28A. WCD 98 is in considerably abbreviated form. And you'll then find what is said about the termination provisions at page 132.
One through two, did you say?
132.
132.
So page 132 of the bundle, and paragraph 119 to 124 should have a margin line. I invite your attention in particular to para 121, where the right to terminate arises by virtue of default by either party. There's a requirement for notice of that default to be given prior to termination in order to give an opportunity for the default to be remedied. It's not remedied within 14 days of that warning notice. There's a 10-day period for giving a notice of termination. Where, having given a notice of default, a notice of termination is not issued, but the default is repeated, party not in default may then, within a reasonable time for the repeated default, issue a notice of termination.
Do you say that's an aid to construction?
Yes, I do.
Well, can you explain for me, at any rate, what it adds to what we've looked at on the face of the contract?
Well, my lord, not a great deal.
It's subject to exactly the same observation that I made to you about a quarter of an hour ago, isn't it? That you can read that in one of, depending on the terms of the contract, you can read it in one of two ways.
Yeah, no, my lord, I agree. Can I just explain what I take from this?
Yes, please.
This guidance note, and it's similar actually in the guidance note to the 2016 version. It treats the parties' termination rights, those of the employer and those of the contractor, as in effect coterminous. It doesn't separate them out and say, well, actually the employer has a right to terminate even if there has been a cure of the default without the right to terminate, continued specified default having arisen. That's different for the contractor. My submission is inconceivable that if the draftsman had intended there to be this new distinction between the approach to employer termination rights and contractor termination rights, that wouldn't have been spelled out. And this certainly wouldn't have been drafted in this form. So that's one point.
Okay.
And then the second, more general point is that when one looks at this 2005 guide, it is explaining the drafting changes between and drawing the user's attention in the industry to what they have done in changing the drafting of the 98 form that everybody was very familiar with to the new drafting. There's no suggestion that sort of a change that's contended for by the respondent has taken place, was intended to take place, and there is the positive explanation they intended to abbreviate the previous version of the form. So that's what I take from this, my lord. In terms of the actual point, does this guidance note tell you very much about the debate that we've been having in terms of explaining it in terms? No, it doesn't.
And your point is that last sentence of 121 is applicable to both employer and contractor?
Yes.
Because it's either party.
Yes.
Does the guide have special status? I mean, is there anything which says you can refer to the guide for the purposes of interpretation of the contract? Does the contract say that, or
No, it doesn't.
it's just a
I
guide?
don't believe it does. It is a publicly available document.
Yes,
But
but it has no special.
it has no
contractual status.
special contractual status. No.
Okay.
And it's not a substitute for professional advice.
Certainly not.
That's what it says.
Particularly
That's what it says at page 115.
particularly conflicting with professional advice.
Um,
115, I'll remember that.
just to draw this part of my submissions to a conclusion, my lords. The third-party commentary that we found indicates that the redrafted wording with which the court is concerned, first, was not considered to have affected the sea change contended for by the respondent, has the effect contended for by the appellant, and contains no criticism of the form as being uncommercial or defying common sense.
Is this page 144?
My lord, it starts at page 144. So there are a series of guides. The first one is behind tab 9, starting at page 144. It deals with page 146, default by the contractor. So there's only a slight amendment. Clause repeats the text of 98 with slight changes to improve the draftable syntax, but the effect is unchanged. Then over the page at 147, says the same in respect of default by the employer. Refers only to 28.1 rather than 28.2, but I don't take anything from that because there is nothing else about 28.2 as there would be if it had affected the sea change. Tab 10, my lord, is another text, and at page 151 of the bundle, it deals with employer default in terms consistent with my case, and so if one were adding marginal lines, it's paragraphs 842 and 843. And then over, please, at 152, at 894, if the employer ends a specified default or specified suspension event ceases within the 14-day period, that's the cure period, or the contractor does not issue a termination notice as above, the contractor loses the right of termination under 893. However, this right is revived if the employer subsequently repeats the specified default. And then tab 11, another guide on the 2005 identical form of words, page 156, just at the bottom. I'm not going to read all of the words out, but alternatively, if the employer ends the default or the suspension event ceases and the contractor gives no further notice, should the employer repeat the default, the contractor may terminate within a reasonable time. Behind tab 12, there's the text on the similarly worded 2011 form, and if you go please to page 160, there's quite a useful flowchart.
Do we have to?
Do you have to go to it?
Do we have to look at follow the flowchart?
Don't have to, my lord. I'd invite your attention to the 3 boxes in the middle at the top. So start, employer fails to pay, yes. Contractor may serve default notice 8.9. Employer stops in 14 days, so within cure period. If no, then you can terminate under 893. If he does stop, yes, no further action, but contractor can terminate without notice. If default repeated, 894. Some points about the effect of that over the page at 161. Those have been highlighted, and they basically it makes the same sort of a point I've been making throughout, and by reference to the earlier cases on the 98 form, that the employer has to be very careful if it defaults, having had the notice on a previous occasion, and then behind class 13 you've got the RIBA guide, 2016 form, which makes the point again at page 164. Finally, we've got the heating, 8th edition at tab 16, which is the edition that provided a commentary on the new 2005 form when that came in. And at page 197, it again repeats the formulation in terms of abbreviation of the form. So we respectfully submit that in this case, when one is looking at the previous iterations of the form and the cases on it, there is evidence as to why the change was made, and it's not to give the form a significantly different effect, which is what's in essence being put against me. It's to abbreviate the wording, but to maintain the effect. So, my lords, unless I can assist you further, those are my submissions.
Thank you very much. Yes, Mr Lewis.
May it please you. I intend to, subject to your lordships indicating otherwise, structure my submissions in 5 parts. First, I'll deal with the textual analysis, the natural and ordinary meaning of the words used in clause 8.9.4 and why our interpretation should be preferred. Second, I'll look at the implications of the rival interpretations forming part of the iterative process of interpretation. Third, the archaeology of the 2016 form, dealing both with the question of admissibility and or weight to be given to the prior forms, and without prejudice to our submission that the forms are inadmissible as an aid to construction on the facts of this case, or should be given very little weight on the facts of this case. My lords, I'll give you some observations on the earlier forms and the JCT guide. Fourth, I'll pick up my learned friend's submissions on the 2 cases under the 1998 form, Rhinewood and Ferreira Key. And fifth, my learned junior Mr Kaplan will address you on third-party commentaries. My lords, turning first to the natural and ordinary meaning of clause 8.9.4, and as my learned friend has indicated, that clause is transcribed in the core bundle at tab 11, page 89. Dealing first with our overarching submission, in our submission, Providence seeks to construe 8.9.4 too narrowly and without proper regard to its immediate contractual context, being clause 8.9 as a whole. In particular, Providence focus on and interpretation of the words "for any reason" is undertaken without proper regard to clause 8.9 as a whole in our submission. The correct starting point, my lords, is to acknowledge the scheme or structure of clause 8.9, and that should largely be controversial. I'll take it quickly because my learned friend has taken you through it, emphasising in our submission the important features of the scheme of that clause. First, the sub-clauses of 8.9 are interrelated in the sense that they operate by express reference to other sub-clauses within the clause. Second, clause 8.9.1 defines a specified default. A default only becomes a specified default if it is the subject of a notice issued under 8.9.1. Third, if notwithstanding a default, no notice is issued under 8.9.1, then clause 8.9.3 is not engaged at all. There can be no termination under clause 8.9.3. Fourth, if a default is specified under 8.9.1, then clause 8.9.3 sets out the circumstances in which a further notice, a notice of termination, may be given under that subclause. The circumstances are expressed by reference to the preceding subclauses. In other words, the timings of the further notice are by reference to the timings of the earlier notice in the preceding paragraphs. Importantly, in our submission, the use of the word may in clause 8.9.3 indicates that the right to terminate is a discretionary one under that subclause. In other words, following...
Discretionary for the contractor.
My lord?
Discretionary for the contractor.
Discretionary for the contractor. In other words, following the expiry of the 28-day period, 14 days under the unamended standard form, the right to serve a further notice arises. But that right to issue the further notice does not arise at all if the default is remedied within the 28-day curing period. In that circumstance, the contractor cannot give the further notice. It does not have a voluntary choice. It is only where the default is not remedied within the permitted period, the curing period, that the right to give the further notice arises under 8.9.3. In that circumstance, the contractor can give the notice, but does not have to give the notice. And to emphasise the points, my lord, whether the contractor in fact gives the notice is discretionary. The contractor has a voluntary choice, and that choice or right could be exercised or not for any reason, as is entirely within the contractor's discretion. If the contractor does not give notice of termination under clause 8.9.3 within the permitted period of 28 days from the expiry of the 28-day period, then the pre-existing right of termination lapses.
Just hold on a second.
My lord, moving straight to the subclause in question, 8.9.4, I'm going to make 6 points. First, the words does not give the further notice referred to in clause 8.9.3 are to be construed in context and specifically by reference to clause 8.9.3. Second, the words does not give before the verb, the words does not before the verb give are consistent with the contractor having had a voluntary choice whether or not to do something, as opposed to an inability to do something. In our submission, an inability to do something is more typically expressed by the word cannot before the verb. To take a oversimplistic perhaps example, just to make the point, Jane does not drive to the shops, is to be contrasted with Jane cannot drive to the shops. The former is more typically used where Jane can drive, but for whatever reason chooses not to, as opposed to the latter, which suggests that Jane is unable to. Third, the voluntary choice implicit within the words does not is consistent in our submission with the express reference back to clause 8.9.3 and the voluntary choice having arisen under that clause but not been exercised. Fourth, on Providence's own case, it accepts that does not give, the words does not give, captures...
Sorry, I think I missed that. I'm being very slow, I'm afraid.
I'm sorry.
Point 3, voluntary choice implicit in cannot is consistent with reference back to 8.9.3.
No, sorry about that. What I said was the voluntary choice implicit within the words does not is consistent with the express reference back to clause 8.9.3.
Thank you.
Fourth, Providence accepts on its own case that the words does not give captures the circumstance of a notice not being given despite the right having arisen. In other words, the continued default extending beyond the cure period, but the contractor not exercising its right to terminate. In our submission, properly analysed, and this is my fifth point, properly analysed and contrary to Providence's submission, it is in fact Providence's interpretation that requires the meaning of the words does not give to be stretched to capture the circumstance where clause 8.9.3 is not engaged at all because no right has arisen at all under that clause. Sixth, the words for any reason in the context of the act of not having given the further notice are reflective of the fact that under clause 8.9.3 the decision to give the further notice is discretionary. There may be myriad reasons why the discretion or right is not exercised by the contractor, but absent clear words which alter the meaning of the words does not give, one of the reasons is not that the discretion or right has not arisen at all. In our submission, in essence, the words does not give for any reason, or for any reason does not give, taken together, and in particular by reference back to clause 8.9.3, under which there is a discretionary right, relate to the reason for not exercising the discretion in question. But one's reasons for choosing not to exercise the discretion to do something only arise when a discretion exists.
So the effect of that is that there has to be an accrued right to serve a notice under 893 before 894 is engaged.
My Lord, yes, that is our case.
Was that a convenient moment?
My Lord, I was about to say, is that a convenient moment?
Yeah, fine. Okay, thank you both very much. 2 o'clock.
All rise at table.